Members, good morning. It's the appointed time. Let's have the election of the chairman first. This is a meeting of the Subcommittee on Mandatory Provident Fund Schemes Amendment Ordinance 2016, Commencement Notice, and we are conducting election of chairman. And in accordance with Appendix 4 and House Rule 21E, can we have nominations for the chairman? Mr. Wong Ting Kwong, Mr. Jeffrey Lam, I accept the nomination. I will be the one who seconds. Dr. M. Zhang will second the nomination. Any other nomination? Any other nomination? Thank you. Is there a need for a deputy chairman? Well, that's I act according to procedures. No need for a deputy chairman. Okay. Well, thank you. So let's move on to the agenda proper. Can we invite the administration team in, please? When they are arriving, can I say something about the commencement notice? That will be, we will discuss the background of the commencement notice. And the Secretary for Financial Services and Treasury has issued a letter on the 14th of October. I believe all of you have it. And the Legal Service Division report and the background brief prepared by the Electrical Secretariat have also been distributed to you as well. So can I first ask the administration to walk us through the paper, and then I will open the floor to questions by members. Can I first introduce the administration team and the relevant organizations representatives? Mr. Eddie Zhang, Deputy Secretary for Financial Services and the Treasury, and also Ms. Wendy Chong. She is the PAS. And also Mr. Darren McShane, and he is the Chief Regulation and Policy Officer and Executive Director of MPFSA. And also from the MPFSA, we have also Ms. Gabriel Yi, Head, Policy Development and Research. And also Head, Investment Regulation, Ms. Stella Yu. And from the Department of Justice, we have the Senior Government Counsel, Mr. Alan Lai. Well, welcome all. Can I ask the DS to walk us through the paper, please? Thank you, Chairman. This is about the DIS, and this was passed in May 2016, and we are talking about the commencement date. So this is a subsidiary legislation on the commencement date of the amendment ordinance. We know that there are new legislators in this term, so we have prepared a PPT to give you the details of the amendment ordinance, as though it's already been passed. So we are asking now Mr. McShane to walk us through the PPT. Darren, please. Thank you.
Let me take members briefly through a little bit of the background as to how we get to this point. As Mr. Chung has said, the legislation has already been discussed, but I'll take you through some of the background as to how we get here. The starting premise is that within MPF, members do have choices about how they can invest their benefits, but many members don't. Many members don't want to, or they can't. And so each scheme has to have rules about what happens in that case when members don't do it. At the moment, this isn't regulated at all. So this has been left to individual providers to make up their own rules, in essence. We're not the only place in the world that does this, but that's the background as to how that happened. As a consequence, as you can see from this slide, different schemes come up with different answers. So some used mixed asset funds, which might have a higher risk exposure. Some use conservative funds. Some use a range of things. In a couple of cases, they just spread the benefits across all the funds in the scheme. Now, no matter what view one takes about what's the right approach, the fact that there are this variety of approaches across similar schemes just can't be the right approach. So that was the basis upon which this project started, that we needed some consistency in that approach to deal with this choice complexity issue. There's been a long developmental process in this, including a public consultation back in 2014, through to introduction of the legislation by the end of 15, and as Mr Chung said, the passage of the bill as recently as May. The proposed implementation date, which the objective of this committee being the 1st of April 2017. So what the legislation does, it requires every trustee to do the same thing basically. As I said, to date they do different things. So the objective of this is just to get them to do the same thing. So there are some provisions in the amendment ordinance which require the trustees to provide this standardised thing, and importantly this standardised approach has a fee control. And the name we provide for this, because it applies to those who don't make the decision themselves, is the default investment strategy. So it's a strategy that applies to the contributions from those who don't give instructions. So this has an impact, it's true, on the accounts of many scheme members. This slide seeks to give you an idea of how this affects different types of members. On the whole, for most members who've already given instructions in relation to their accounts, this has no impact on them whatsoever, and that is the vast majority of members, the vast majority of accounts, and the vast majority of money in the system. So this focuses on going forward. To take the second point there, for new members coming in, the impact of this starting on the 1st of April is that from a new member coming in on that day, setting up a new account, if they don't give instructions, then obviously, as a default, the investments will go into the DIS. That's the whole premise of the new law. So that's relatively simple. There are some transitional provisions about what happens to current accounts. You know, the new world is always easy. In these types of movements, it's the transitional provisions which do have some complexity. So the legislation does provide some transitional provisions about how this affects existing scheme members. Obviously, as I said, this only affects those existing scheme members who have not given instructions for any of the benefits in their account. And for those types of accounts, there's a process by which they'll be moved into the default investment strategy over time. And I'll speak a little bit more about that process in a minute. As I said, for the most members who've given their instructions, the actual commencement on the 1st of April would not affect them. But of course, they have the option to choose to invest in the default investment strategy from that date. So they can give new instructions at any point in time from that date to invest their existing or future benefits in this new default investment strategy. So it has slightly different impacts on different members as subject to how they integrate with the system at the moment. But the simplest case is new members from 1st April, unless they give instructions or until they give instructions, then their contributions will go into the default investment strategy. A large part of the law, and more of the technical part of the development, which took a long time to work through with the industry, and we discussed that some length with members through the Bills Committee process, was if you're going to have a standardised approach, well, what is the standardised investment approach? So a lot of the legislative provisions go to how this actually is invested, and that is set out in some detail. And there are a couple of principles there. Firstly, that we're going to achieve the most diversification benefits that we can. So the benefits in this strategy will be invested in a diversified manner, and importantly, because we need to deal with, in an average sense, how we best protect members, the real risk in long-term investment is what happens right at the end. And the analysis we did showed that this is where members can really get hurt if things go bad right at the end. So the law provides for reducing exposure to higher risk assets as a member gets older. The mechanism we do that is a little bit complicated, but in essence the way we've done it is to as little change as possible. So we need 2 new constituent funds. As members may know, a MPF scheme has got a number of investment options, anywhere from 5 to 20 in a typical scheme, and these are called constituent funds. So we need 2 constituent funds to achieve the de-risking and strategy I just mentioned. The way it works is that up until age 50, a member's contributions to the DIS will be invested wholly in this constituent fund called the Core Accumulation Fund. And the pink bit there represents the risky assets in that particular constituent fund. So 60% of that fund is invested in riskier assets, that means equities and shares, and 40% invested in lower assets, lower risk assets. In contrast, when you get to the end of the working life and to pass the retirement age, or claim age as it's called, the investment approach is we've taken the risk off the table by that stage. So there's a constituent fund called the Age 65 Plus Fund, which is only 20% equity. So that's much lower risk. And that's the fund that money will stay on from age 65, or technically actually age 64 in the way it works in the law. So we need a process for moving people from that age 50 to that age 65, and that's some of the technical aspects of the design of this. So we have all these steps in theory. How do we get people from one down to the other? The way we do it is to gradually move money out of the Core Accumulation Fund and put it into the age 65 fund. So between age 50 and 64, people will have some money in both of those funds, but each year the trustee, the member doesn't have to do anything. The trustee will automatically move some of the money out of the higher risk fund and put more in the lower risk fund. So at the end of that glide path, as we call it, from age 64 and 65 onwards, the member will be 100% invested in the lower risk fund, the age 65 plus fund. So that's the mechanism we've used and is set out in the law to achieve that de-risking. The other important element, as members know, is that the default investment strategy comes with fee and expense controls. This was an important part of dealing with members' concerns about the cost of their interaction with MPS providers. The fee control in the law as a starting point is 0.75 of the fund value each year. And this covers all of the payments for the services of the providers indicated on the right. So trustees, administrators do all the administration work, obviously. There's also investment managers who do a totally different function. The investment work also falls within that. The work that the sponsors and promoters do in establishing and promoting and distributing the scheme, custodians on the whole, and the same types of funds that are charged to lower level funds are included in the rather complex calculation. We provided guidelines as to how to apportion these across the CF level and underlying fund level, because we don't want people just to be able to hide this at underlying funds. So the law specifically sets out a mechanism for uplifting the costs and fees at the lower level so that all of that is captured holistically in that 0.75% of net asset value each year. This is actually a daily cap set out in the law, but on an annual basis this works out at 0.75%. The other cap within the law is an expense control beyond fees, which are sort of a profit item or an item to cover the cost of providing the services from certain parties that I indicated on the previous slide. There are expenses. So there are things that come out of funds which are actual acquittals on the basis of a cost incurred. So these are incurred by the fund and include things like auditor's fee and lots of miscellaneous things, printing expenses, bank charges, government fees, and these are defined in the law. So these are subject to a different cap, which is also an annual cap of can't exceed more than 20 points, so 0.2% of the net asset value of the fund. So in combination, these are considered as important constraints on the way that fees and expenses will affect the returns of members in the default investment strategy. Considered important if we're designing defaults that they have to be able to provide good value to members, and it's the combination of those two proposals that achieve that. In terms of how that works for members, so at the end of the day there's this new thing, the default investment strategy for people who don't make choices, but the law also requires that the default investment strategy itself is a choice. So people can choose that. So this becomes a new choice option for people as well, for those who want to make choices, and they can decide, for instance, to consciously choose to invest 100% in the default investment strategy, or they still preserve all their other rights to choose other constituent funds. So they can choose above or below the line. If they want to put part of the money in a variety of funds, they can do so, including the two new funds, the two constituent funds I mentioned that are part of the default investment strategy. So members will be able to allocate their investment choice across the range of constituent funds, including those two new ones. So that's, in effect, a new range of choice available for members beyond the ability just to invest everything in this fund. And if they don't want to make any choice, well, that's exactly what this is designed for. They'll end up in the default investment strategy. So the implement timeframe for this, and this looks a little bit to the transition. So how do we deal with this complex issue of those current accounts where there are no instructions? On the assumption that this commences in April 2017, the law sets out a transitional period as to how this works. Within that 6 months, the affected accounts will get a notice from the trustees. It's the trustees' job to identify these accounts and to send out a notice to all of these accounts within that first 6 months. The member then has 42 days, and what the notice says is that unless I hear from you in the next 42 days, this account will be invested in the default investment strategy going forward. So that's what the notice says. So the member has that 42 days to get back to the trustee and say, no, I want to do something else. Up to this point they've done nothing, but this is a fresh opportunity for them to make a decision. They could make that decision any time from today, in essence. They can give instructions to the trustee and fall outside that provision. But this is for those who've not, by the time the notices are sent out, made any choice. They get the notice and they've got 42 days to get back to the trustee. If they do not get back, then the obligation on the trustee is within the next 14 days to invest that account in accordance with the default investment strategy. So for someone under 50, that means they put all the money into the core accumulation fund. Someone between 50 to 65, they'd invest it in accordance with the allocations I mentioned in one of the previous slides. So the trustee will do all that for the member. The member doesn't have to do anything. This is about relieving the burden from the member of having to work through that. There are a couple of exceptions to that, and we discussed some of these at length in Bills Committee previously. That transitional requirement about these are accounts that have got no instructions and are wholly invested in the current default, that will not apply to members who are over 60 on commencement date, so on the 1st of April. And the reason for that being there seemed little point in changing their asset allocation when they're so close to being able to withdraw the benefits from the system. The second category, who will get the notice, but there's a special rule about those who are currently invested in guarantee funds. We do not want them to be denied the benefit of the promise contained in the guarantee, so the trustee has to do some work to work out whether the member would be better off, whether the guarantee has value, and if the guarantee has value, the member stays in the guarantee fund, and the actual requirements on the trustee are set out in the law. So they're set out. In terms of regulation and supervision, of course, the bill also sets out provisions about extending the MPFA's powers in relation to supervision and regulation if there's any failure to comply. So our existing powers are extended to the DIS, as well as some new provisions. There's provisions for auditors and service providers to report any non-compliance to the authority, and the authority can actually request auditors' investigation and report in relation to any concerns that we might have. The law also sets out the consequences if there's failure to comply with any of these obligations, and there's lots of obligations in there on trustees. The consequences being the possibilities of revocation as an approved trustee in the most serious cases, suspension or termination of scheme administration, and also a range of financial penalties that can apply for trustee failure to comply with the obligations. So in terms of the process of this committee, the commencement notice was tabled on the 19th of October with a target of commencing the legislation on the 1st of April 2017. Of course, since the passage of the bill, the authority and the industry has been actively involved in trying to educate members and make them more aware of this thing that is coming, because it's a big change. Up to this point, the authority has been engaged in one particular campaign. We split this into 3 particular phases. The first part being from June to November, sort of a preparatory campaign to get people interested enough to perhaps go and check what their current status is, so they're not surprised about what may happen next year in relation to their account. So we've engaged in advertisements in newspapers and websites to remind members that this is coming, that it'll have an impact on them, and to encourage them to check with the trustees, because that's where they have to go, to check with the trustees that their address is up to date, for instance, so that they will get the important communication which will come very shortly. The next phase will be a larger scale campaign once there is a clear commencement date and that is passed. Then we will start a campaign in a little more detail about the features of the DIS to let people know what's coming and to remind them that they will be getting important notices. And importantly, they will get something in all likelihood before the end of the year, because the amendments to all the documentation will be sent to members along with a detailed notice about the impact on their account. And the third phase, of course, will be after this commences. The authority, with the support of the industry, will commence a large-scale publicity campaign, again emphasising the details of the DIS, its implementation, and importantly reminding people, for those who will be affected, you will get this transitional notice sometime in the next 6 months, and reminding them of how important that is to them and the action required of members both in advance of that and after they receive that notice. Chairman, we have some of the publicity material here if members are interested. I won't take members through them individually, but of course we will have a range of newspaper, online and search engine based advertisements. We have a dedicated web page on our website dealing specifically with DIS issues as they develop. The focus at the moment is, as I said, encouraging members to be involved enough to perhaps check their account status and make sure that the trustee has their contact details so they can receive the important communication to come. There have been specific activities around certain types of accounts. Casual employees under the industry schemes have a different set of issues. Many of those accounts didn't have as much contact information as master trust accounts, so we have specific campaigns related to that, and there have been some specific activities around high publicity events such as horse racing opportunities to remind those people that they should check that they are aware of their accounts and their contact details are up to date. And this continues the theme of emphasising for those industry scheme casual employees and assisting them to make sure that they are within contact of their trustee and they're interested in what's happening to their account, including a mobile text message to all employees in the construction industry. So there's a variety of strategies adopted to make sure people know what's happening and what's coming in that respect. Chairman, that brings us up to date with preparation to date, and we're happy, of course, to take members' questions.
Thank you, Darren.
Yes, first of all, I'd like to tell members that the contents of the paper in our previous legislative year, it had already been endorsed, and the committee has to deal with the legislative timetable on this occasion, and we have 3 dates. We have the vetting date, and then we need to report back to the House committee, and we also need notice to meet the notice deadline for amendment. We have already discussed and endorsed these, but since we have some new LegCo members, I'd like to hear if you have any questions, and we have officials in attendance to respond. So first of all, Mr. Luk Jong-ho. Thank you, Chairman. Let me read the list. So we have then Chen Ginbo, Zhang Qiuhong, Pun Xiupeng, and Zhao Hodeng. Mr. Luk. Thank you, Chairman. The Federation of Trade Unions are concerned about the rate of return on the MPF and the fees. This piece of legislation, we had raised some amendments on the last occasion, but they were not endorsed. So in our new legislative term, we would like to follow up on the rate of return. Do we have any mechanisms? If the returns are less than a certain threshold, let's say we could make reference to inflation, there should be some penalties. Maybe we could deduct some management fees or even their status as a trustee. The 7.5% plus 2%, the public feels that that is not low enough. So could we have some review mechanism? Ideally, it should be annual. And regarding transparency, I think the MPFA in the rate of the investment return, they don't have sufficient communication with the public. For example, the trustees' rankings, what's the situation there? And I'd also like to ask a specific question. That is, the MPFA, have they assessed the current situation? That is, the number of accounts that have not given instructions, what the percentage, and after enacting the new legislation, how many accounts will be transferred to the DIS, and also on publicity and education. I think when the new legislation is enacted, the whole MPF market will face a change in the landscape, especially for automatically transferred accounts that had no previous instructions when they transferred to the DIS. So we have the core fund, the core accumulation fund. So the portfolio is quite similar to previous funds. It's quite similar to the medium level risk, but in the past it might be 1.5% or higher management fees. This is relatively cheaper. So investors, it might be beneficial to investors, and it's worthy of more publicity. Some people might feel that since I have not made a choice, then they would fall into the DIS, so there might be some misunderstanding there. So they need to step up the publicity and education. Who can respond to that? Let me respond briefly, and if necessary, Darren can supplement. Chairman, that's correct. In discussing this bill, the FTU had made a lot of suggestions. I need to emphasize that the return is an unknown, and if we were to establish some penalties based on some unknowns, that is not appropriate. We made an analogy. We cannot ask the observatory to give us accurate weather forecasts. There is some shortfall. We understand that some account members wish to have a better understanding. There is a platform with the MPFA. The rate of return over 1 year, 3 years, 5 years, and 10 years. We have these records, and members of MPFA, they can go to the website and make some comparisons. So we're also willing to do more publicity so members can have better access to this platform. We also pledged that after implementing the DIS, in 3 years' time, we will come back to LegCo to report, to review. Why is it 3 years? It's because we're talking about long-term investments. We don't want to just rely on figures from 1 year and make rash decisions. So we feel a review in 3 years' time is more appropriate. Of course, we can meet regularly with LegCo and report on the progress. I agree with Mr. Look. We do have fee control. This is the first time, and Mr. McShane had told us members of MPFA, they don't need to choose the DIS. There's also another choice. They can choose accumulative funds or the 60-plus fund. So if a member feels that they are comfortable with risk adjustment, they don't want to come under this control mechanism, fee control mechanism, they can make a decision to choose the cumulative fund, and we agree with Mr. Look. We need more publicity in this area. Okay, thank you, Eddie. Mr. Chan Ginbo. The insurance industry, we had expressed our view through the Bills Committee, and our concern was that if the public don't understand the impact and if they did not make the appropriate choice, then many years down the road they will come and complain and say that in the past they were in a low-risk fund, and why were they switched into a higher risk. So we encourage them to switch. If they wish, they should move into the DIS, and after voting we felt that they should be given an opt-out option.
But this isn't desirable. Well, but we've decided on it anyway. So we count very much on the public education and publicity work. So I note that you will be devoting a lot of resources to do publicity and education. But I think the focus in all these efforts should be this. And that is, if the MPF member receives a notice, he should respond within 42 days. He must respond. That should be the focus of your publicity, or else the money will go to the DIS. So that should be the main message that you should deliver, and that is, he should respond within the 42-day period. If he doesn't do so, the scheme will transfer your contributions to the DIS automatically. Of course, there will be a de-risking following age. But so anyway, this is a more aggressive investment approach for the core accumulation fund. So I hope that in terms of the message to be delivered in the education publicity effort, that should be the focus. And also, secondly, is the industry prepared? You are suggesting that it should commence on the 1st of April. The government and the MPFSA, have you communicated well with the schemes? How is this computer setup and the other arrangements on the part of the schemes? Thank you, DS. We have talked to the industry, and the industry is confident that everything is ready by 1st of April. What about the publicity and public education? Well, thank you, Mr. Chan, for your comment, and we would take that on board. This is a very good comment, and we would definitely consider it. Mr. Chan talked about publicity and public education. I think you should do more, a lot more, because in the past we've seen new laws being implemented, and people do not know too much about these new laws in the end. So if you can do more between now and the 1st of April, then that would do good for everyone. Next one, Dr. Fernando Zhang. Chairman, we welcome this DIS. Well, maybe it's not perfect, including the fact that there's still room for lowering the fees. So if you look at the tracker fund, well, the fee it charges is lower than the cap you are proposing. In any case, I would like to know whether the administration has done any sort of simulation estimates using this DIS, come up with the possible scenarios in terms of low, medium, and high risk investment strategy. What is the fund expense ratio in the say past 5, 10, or 15 years, and in terms of 0.75% and 0.2%? How does that compare to the rates in the existing products? What is the percentile like? Can you tell us about that? Darren?
Chairman, let me try to answer those questions. We agree there's room for lowering fees. These need to be established, and as Mr. Chung has said, that needs to be reviewed going forward. In your question of the fees and the FER, yes, FER has come down. 2007, when these figures were first available, the average expense ratio figure was 2.1. That's now 1.56. So that figure has dropped about a quarter in that period. But yes, that figure is still well above the figure one gets to if you extrapolate from the two caps here. I should say those, if you add up the 0.75 and 0.2, that does not necessarily exactly equal an FER figure. Let me emphasise that so we manage the expectations going forward, but it should approximate it. So on the whole, that's broadly in the park. So yes, these funds will be significantly lower than the average. They're also lower than the vast majority of funds. We do have some low fee funds at the moment, but these new funds will all be well below the benchmark for getting onto that list. So that is important. In terms of the tracker fund, your observation is correct. The tracker fund's management expense ratio, which is calculated quite differently to our fund expense ratio, is very low, perhaps 20 basis points or lower. But that only represents the investment management component. It's to be remembered that the largest part of that 75 doesn't relate to investment management. It relates to the administration of the MPF scheme, which is quite different to administering just an exchange-traded fund. You may remember we used a consultant to do some work on estimating the cost of administration a few years ago. Ernst & Young's report calculated that the cost of administration, ignoring that investment part, was 75 points, which suggests that the 75 is quite an aggressive, because it does include the investment costs of things like tracker. We're still looking at the applications coming in, but many of them are adopting a passive index-based approach. So as far as the investment part goes, yes, we'd be expecting some of the investment costs to be getting down towards those sorts of ranges. And there are some larger providers of index-type strategies who are interested in working with our trustees. So we're excited about the possibility of getting those costs down quite dramatically as part of this implementation. The scenario analysis, I'll give you a very long answer on this, but I'll try to be brief. We did a lot of work, and we had retained a consultant from the OECD to work with us on doing scenario analysis of different investment strategies. To cut a long story short, yes, you get a huge dispersion of returns depending on your strategy. To take the tracker fund, of course, the average would have been higher, but as Hong Kong equities, we would have left a lot of people with very bad outcomes at the end because of the volatility. And we also modelled pure cash and everything in between. The approach we got to at the end through his work and working with the industry and our observations about how others are doing this around the world is the strategy we have. Overall equity exposure in the low 50s between those two funds, so about 53%. But importantly, to remove that tail risk of things going really wrong at the end is the scenario that he worked on. And so the de-risking that we do 15 years from the end is designed to deal with that and protect members from those bad outcomes.
好，我仲有一個跟進問題咧，就係關於
I have a follow-up question. We have this commencement date. We noticed that many who have the MPF accounts, they don't know about their own investment strategy. Are they being put on the default investment arrangement already, or what funds their contributions have been put in? Well, they don't know about that. Now, for new people, they would be investing into their contributions to be put into the DIS. But some existing account holders don't know about their present situation. So will the administration ask the MPF scheme providers give a notice to all existing scheme members so that they can indicate their willingness to transfer their contributions to the DIS in the simplest way? We know that this fee for the DIS is more reasonable. And going by the different scenarios analysis, the DIS may be the best approach for people in terms of risk management. So should all MPF account holders be notified of this new arrangement, and they can come into join the scheme more conveniently? Yes, we will do that. Thank you for your comments. Every trustee should add in 2 funds in every scheme. So the trustee should send letters to all members that these 2 new funds will be available. And when the amendment ordinance actually comes into effect, we would also notify those who have never made any instructions to ask them to make a decision within 42 days. And if they don't have any indication, then the contributions will be switched to the DIS. And the MPFSA has is doing a lot of publicity in newspapers, which sets out the content of which is whether you have received any letters about your MPF recently. So this is one thing that we would definitely do. Let me seek a clarification. So the trustee will be sending letters to all scheme members, right? And all they need to do, I mean the members, is to indicate whether they would like their contributions to be switched to the 2 funds or the DIS, right? Yes. Well, that's right. That will be undertaken on the 1st of April. Yes. Mr. Chan Kim Po also mentioned something about publicity in public education. We're all concerned about it, whether you are the employers, employees, or the trustees. We all hope that the government can do a lot more publicity. So apart from the conventional publicity channels, well, you mentioned about newspapers. Well, are newspaper advertisements that effective? A lot of people don't read newspapers anymore these days. What's most important is everyone is made aware that this is a new mechanism. Now, with regard to the management fee, we understand that depending on the fund size and also the participant or member number, that will affect the management fee. But for the members, what matters most is the management fee is low, the investment return is high. So please pay attention to all these. Next, we have Mr. Poon Siu Ping. The ordinance was enacted in May, and I supported that. And you are proposing a commencement date next April. I agree that publicity should be enhanced. I have a simple question. Well, it's been 6 months after the amendment ordinance was enacted. Now, for those who haven't given any instructions, and they can now make instructions. Now, have there been any changes in the past 6 months? For those who haven't really made any instructions, have they taken the initiative to make instructions? Or Eddie or Darren?
We have been working with trustees to get a better feel for how many accounts are affected by the transitional provisions. Those numbers do seem to have come down since we first asked this question during the Bills Committee last year. Whether that's because the data is better and the trustees are looking at it closer, or because people are actually making choices, we can't disaggregate, to be perfectly honest. Although, anecdotally, on the basis of the discussion with the trustees, we don't see that there have been a lot of people who are rushing in to make new choices. So I'd have to say there's not been a surge of people moving out of defaults into something else at this stage. There are two sides of this coin, though, of course. In the one sense, yes, it reduces an administrative issue the more people make choices, but the more people make choices, the fewer will end up in the DIS. So we need to be cautious about this, and we've sent out guidelines or circular letters to the sales forces to tell them to be very careful. Be careful what you're telling people here, because if you go in and give them advice about individual fund choices they should be making, you've got to do suitability assessments. You can't just say don't invest in the DIS or do invest in the DIS. They have to actually have a basis for making that, having regard to individual circumstances. So we're asking the industry to be very cautious and careful in relation to what they say about that.
Next, we have Mr. Holden Chow. Thank you, Chairman. I have several questions here. If I have repeated what others have said, please pardon me because I just stepped outside a bit just now. I noticed that for this core accumulation, for core funds, 60% of the funds will be in the high risk category.
I heard initially that the core fund was for people who didn't make choices previously. So this core fund compared to existing low-risk funds, how does it compare? Because it seems that this core fund has 60% in some high-risk products. So I'd like to understand how does that compare to existing low-risk funds? Is it the lowest, or are there other funds with a lower risk? And secondly, I'm aware you say that account holders can make a choice. They can choose the 60 plus or the cumulative fund. So the fees, is that lower than 0.75%? I'd like to clarify that. Another question I have is, the paper says that prior to 1st of April 2017, those who are 60 years old and who have not made an investment choice, they cannot switch over to the DIS. So I'd like to understand what's the reason for that. And there's another condition. If the account holder, if they are in some guaranteed funds, and after joining the DIS, it would be even lower than the guaranteed fund, then they are not encouraged to make that switch. I understand, but how is that judgment made? Is it the bank providing this information? They had pledged to give a guaranteed, and then they won't be allowed to switch over to DIS? Is it decided by the bank? So those are my questions. Thank you.
The core accumulation fund, yes, is generally riskier than most current defaults. If you look at the current range of defaults, some schemes use the conservative fund, which is much lower risk. That's almost no risk. Some use guarantee, but some also use target date funds, so they've got some equity content exactly in the same way as we have under this proposal. Some use mixed asset funds. But I would concede that on the average, this solution, the core accumulation fund, does take on more risk, but it does so deliberately. Because part of the consequence of leaving this to trustees' discretion or providers' discretion in the past is they have tended to take the approach, not just here in Hong Kong but elsewhere in the world, that it's the least trouble to them, so that they will face less issues. But that's not necessarily the best result for members. The sort of scenario analysis we did, I referred to in the previous answer, was very much looking at this issue. So what's the consequence at the end of the day, after 40 years saving, of taking these different approaches? And as a matter of consensus with the industry, academically, and having regard to what's done elsewhere, we think this is the best approach, albeit we take them out of this 60% equity fund from age 50 so that we reduce the prospect of things going very bad towards the end. But yes, this is higher risk than many of the current default approaches. I'd agree with that. In terms of choice, if people choose these two constituent funds, yes, they get the benefit of the fee caps. Even if they're not doing it through the DIS, if they choose the core accumulation fund or the age 65 plus fund, yes, they get the benefit of the 0.75 management fee cap. In terms of the switching, perhaps I didn't describe that very well. Nothing prevents anyone over 65 or anyone in a guarantee fund from switching to the default investment strategy. What I was referring to is the transitional process. So for current accounts, whilst for those affected accounts for people who haven't given instructions at the moment, they will get the letter. If they don't respond, then they'll automatically be moved. That doesn't apply in those two particular cases. So it's only for those transitional accounts. And the reason we didn't do it for those over 60 is we thought it probably not best to move them automatically without them necessarily doing anything, because they're so close to retirement that the investment strategy we've adopted just won't have time to have impact. So we took them out, but they can, and they will be told through the notices we'll give to everyone, that they can make the choice to invest in these if they want.
As long as they provide you with the consent, then it
Exactly.
could be transferred.
Yeah. Like everyone else, they can.
Fair
and
enough,
the same with the guarantee fund. The concept with the guarantee fund is they're a bit different. We have problems like with these. Well, what's going to happen in the future is one thing, but we've taken the brave decision that we have a default approach for going forward. So, yeah, there'll be winners and losers in that, but we've made that decision. For guarantees, it's a bit different because you've got accrued benefits, you've got accrued rights, and we didn't want to take people out of a guarantee fund where the value of what they've already accrued would be lost. So there's some calculations which are a little complex for the trustees to do in that case, but that's a special case. Again, though, if the member wants to, at any time after 1st of April, they can go into the defaults.
Okay. Okay.
就算佢哋係4月1號之前。
Even prior to 1st of April, if they do not make a switch, and after 1st of April, they can still make that switch if they do so. Okay, next, Mr. Chung Kok Ban. Thank you, Chairman. I have some questions for clarification. The first, in the slide, the DIS, which page are you on? Page 4 of this PowerPoint. It says that the amendment ordinance requires each trustee to provide a highly standardized fee-controlled default investment strategy. So this highly standardized, these trustees, did they sit down together and figure this out, or did the MPFA participate, or did the government participate in drafting up this highly standardized DIS? That's the first question. And second question is on timetable. So after 1st of April 2017, on page 16, there will be a 60-day period, and account holders will be given 60 days to notify the account holders, and then there will be 42 days for members to opt out. So that means by the end of 2017 we'll be able to commence. Or does the 42 days and 17 days, 14 days, is it included in the 60 days? And the third question and last question is penalties in case of breaches or non-compliance. So the MPFA, will they decide on the financial penalties of non-compliance? Will they suspend the license and so on?
Try to answer those. In terms of the development of the details, that's been a very broad church contributing to that. I outlined at the commencement the process we've been through in developing this. So the public consultation even included many of these investment parameters. So that goes right back to 2014. Even before then, we've been talking to the industry in some detail about how to do this, but we had regard to other things too. The industry didn't get exactly everything they wanted in terms of the investment strategy because, as I said, we used some external consultants from the OECD to do some scenario analysis for us on what was the best investment approach. Ultimately, of course, we came to you. We came to LegCo with these proposals in the bill, and some of those were discussed at length here. So there's been a lot of input into that investment approach. I think the industry certainly agrees as a consensus at the end of the day that it represents the best approach as a default. It's not right for everyone individually, and individuals might want to look at it, does it suit my circumstances, and they may choose something else. But when looking to how to structure for a default, it's consistent with international practice, consistent with the research we've got, and is based on consensus with the industry and indeed, I hope, the legislature, because these were discussed here. In terms of the timetable, which is up at the moment, the way this works is, so what kicks off on the 1st of April is the 6-month transitional period. So within that first 6 months, the trustee has to send these letters to the affected accounts. We're leaving it up to them as to when in that. Some want to do it all at once, some want to spread it out across their membership. Most are inclined to do it earlier rather than later in the 6 months, but they've got 6 months to send that letter out. Once the letter is sent out, the member has 42 days to respond. Only at the end of that 42nd day does the next 14 days kick in. So within the 14 days after the 42nd day, the trustee, if they haven't got a response, has to move that account into the default investment strategy. So if you take the absolute outliers on that simple design, there are a few exceptions to this I'll just come to in a second, but so the latest this could possibly happen in the simple case would be the letter would go out the last day of the 10th month, so the end of October, add 42 days to that for the response period, and within 12 days after that the money would be moved over. So within that time frame, in the normal case, would be the last date that all this transition would be finished. The exceptional cases are, there are some special rules in the legislation about cases where there is returned mail because it wasn't received. The trustee has to, in effect, do the process again. So there are some exceptional cases in that, but for the vast majority of affected accounts, which is only a subset of the overall accounts, of course, this will be completed within that 6 months plus 42 days plus 14 days. I haven't actually got the calendar on me, but that is the end of October, mid-November, so by early December 2017. The penalties, yes. The law, like any of the other financial penalty decisions within the law, is left to the discretion of the authority, and any decision about revoking or suspending trustees or their administration of a scheme is, as in other cases, left to the discretion of the authority, albeit subject to the normal review cases. Some of this is subject to a review committee, and all of it will be subject to judicial review as necessary.
OK， 大家有冇其他問題？
Any other questions? If not, then let's take a look at the legislative timetable. Just now, we have the commencement date of 1st of April 2017, and now the scrutiny date deadline is 16th of November. Well, this is somewhat urgent because we're already on the 11th of November. So if you don't have any opinions, then I suggest let's amend the deadline to 7th of December, because we still need to report back to the House Committee. And if we have the deadline of 7th of December, then on the 25th of November, we can report to the House Committee and submit our report. And we can put forward a motion to amend this commencement date, and that needs a 5 days notice. So that would take us to 30th of November. Any questions on that? So we agree to move the deadline to 7th of December. So I think that concludes most of the work of this committee. Do we see the need for another meeting? If not, then unless unforeseen issues occur, otherwise this will conclude our meeting and committee. Okay, thank you.